factual transaction, a purely commercial transaction, has been criminalized. And it's a transaction that took place nearly 5 years ago. So it is like a nuclear bomb. This is a nuclear option to look for any material that will be used to drag the Deputy Chief Justice into this trial. Thirdly, we are going to demonstrate that there is no factual foundation. There is no factual foundation for instituting these charges against the Deputy Chief Justice. Fourthly, we are going to demonstrate that these proceedings are an abuse of the process of the court, and that matters which naturally fall within the province of the Ethics and Anti-Corruption Commission, and every case, including the ones you have dealt with, were investigated and the recommendations given for prosecution by the Ethics and Anti-Corruption Commission on the face of the charge sheet, although these are corruption-related offenses under the Anti-Corruption Act. This charges has been brought by the police, and we are going to demonstrate why the Director of Public Prosecution on this matter chose to use the Director of Criminal Investigations, who turned out to be user-friendly, as opposed to using the legal regime, the statutory regime that relates to offenses created under the Anti-Corruption Act, and for the purpose for which this court has been established as an Anti-Corruption Act. Otherwise, for normal penal code cases, we would have gone before court number 1. Finally, amongst other reasons which probably we may not need to advance for purposes of persuading Your Honor that this matter should not be taken, a plea should not be taken, is that despite the fact that this matters, the action complained of in the charge sheets took place nearly 5 years ago, in a space of 5 hours yesterday, both accused, the first accused was arrested. Taken to the Director of Criminal Investigations. And by 5 o'clock,